In this lecture, we shall have a quick overview of the law on capacity to contract. As you are aware, we have already discussed the elements of a valid and a binding contract, and capacity was identified to be one of the elements of a valid and a binding contract in Ghana. What this means is that before a person can enter into a valid contract, you are required to be clothed with the required capacity that the law requires. So in Ghana, what is the age of contractual capacity in Ghana? The age of contractual capacity in Ghana is governed by the rules of the common law and therefore is 21 years. 21 years. Now, I'm aware some of you will be reading books where to show that the age of contractual capacity is 21 years, reference will be made to the Interpretation Act of 1960 CA4. I have to inform you that that law has been repealed. Some of you too have been making reference to the Companies Code of 1963, Act 179. That one too has been repealed. So bear in mind that the definition of an infant is still governed by the common law, and then the minimum age is 21 years. The Interpretation Act 1960 has been repealed. The Companies Code of 1963, Act 1792, has been repealed. The definition for an infant is governed by the rules of the common law, and it is still 21 years. Now, when an infant enters into an agreement with an adult, for example, a person who is 20 years, 18 years, 19 years, enters into an agreement with an adult, somebody who is about 30 years, 40 years, what does the law say about those kinds of agreements? Can the adult enforce the agreement against the infant? The common law is that when an infant enters into an agreement with an adult, the agreement cannot be enforced against the infant, but it can be enforced against the adult party. So take note of this, that when an infant enters into an agreement with an adult, the common law is that the infant can enforce the agreement against the adult, but the adult cannot enforce the agreement against the infant. So take note of that one as the rules governing the capacity to contract under the common law. But there are exceptions to this, because if you take note of what I have said, we are saying that if an infant enters into an agreement with an adult, the infant can enforce against the adult, but the adult cannot enforce against the infant. There are exceptions to this particular rule. There are exceptions that would regulate instances whereby an adult would be able to enforce an agreement against an infant. What are those exceptions? One is contracts for necessaries. If it's an agreement for necessaries, the adult will be able to enforce the agreement against the infant, and the adult will be able to recover a reasonable amount for the necessaries that have been supplied. What are necessaries? Necessaries are goods suitable to the condition of life of the infant and to its actual requirements at the time of delivery. Necessaries are goods suitable to the condition of life of the infant and to its actual requirements at the time of delivery. And over here, I refer you to look at section 2, subsection 3 of the Sale of Goods Act, Ghana, 1963, Act 137. Also take a look at the case of Nash and Inman. You remember Nash and Inman, the infant who ordered 11 fancy waistcoats. And also look at the case of Chapo versus Cooper. All of these will let you know that if it's an agreement for necessaries, then the infant will be required to pay a reasonable price for the goods that have been supplied. Then we have beneficial contracts of service. These are contracts also that the adults can enforce against the infants. And therefore, for beneficial contract of service, the law is that when an infant enters into a contract of apprenticeship or a contract of service, under which the infant receives instruction or training, that contract will be binding on the infant, provided the terms of the contract, construed as a whole, they are substantially to the benefit of the infant. Again, when an infant enters into a contract of apprenticeship or a contract of service, under which the infant receives instruction or training, that contract will be binding on the infant, provided the terms of the contract, construed as a whole, they are substantially to the benefit of the infant. And the authorities over there, remember the case of De Francesco versus Barnum, remember the case of Clement and London Northwestern Railway Remember these two cases, because if an infant enters into an agreement where he's under apprenticeship to learn hairdressing, to learn masonry, to learn carpentry, you are under an apprenticeship to learn a particular trade, you are being trained for a particular purpose. The law says that those agreements that you enter into, considered as a whole, if they are to your benefit, they will be enforceable against you. If you forget every case at all, don't forget the case of Dave Francesco versus Banu. Now bear in mind, this beneficial contract of service, they have been extended to also apply to contracts that allow the minor to earn a living through the exercise of a profession or occupation. They have been extended to include contracts in which the minor is earning a living through the exercise of a profession or trade. So you see some questions where you'll be told that the minor has going to take up a form of teaching, to be teaching somebody's son by way of private classes, or the minor has gone to actually learn how to make money through maybe boxing or something. Now, in these particular things, the beneficial contract of service has been extended to actually include agreements that allow the minor to earn a living through the exercise of a profession or occupation. And over there, I invite you to look at the case of Doyle. Doyle is D-O-Y-L-E versus White City Stadium Limited. Doyle, D-O-Y-L-E versus White City Stadium Limited. So the principle is that this beneficial contract of service, which I have told you that it applies to contracts where you are receiving apprenticeship, you are under apprenticeship. Those ones have been extended to also apply to contracts in which the minor is earning a living through the exercise of a profession or occupation. And the authority is Doyle, D-O-Y-L-E versus White City Stadium Limited. But you have to note that trading contracts are not binding on the minor, no matter how beneficial they are. If it is a trading contract, it is not binding on the minor, no matter how beneficial the contract is. Therefore, if a minor decides to earn a living by trading, there's an absolute bar to liability against the minor. This means that if an infant supplies you with goods, or is agreed to supply you with goods, and he fails to deliver the goods, if you bring an action against the infant, you will not succeed, because an infant is absolutely barred from liability from trading contracts. The authority for this is Cowen, C-O-W-E-R-N, versus Nield, N-I-E-L-D. So if it's a trading contract, there's an absolute bar to liability for the minor. The third exception of contracts that are enforceable against the minor are avoidable contracts. These are contracts in which a minor acquires an interest in some matter of a permanent nature, which gives rise to continuous or recurrent obligations. These are contracts in which a minor acquires an interest in some matter and is of a permanent nature, and it gives rise to continuous or recurrent obligations. Now, these contracts, they are binding on the infant unless and until he repudiates the contract during his minority or within a reasonable time after attaining the age of majority. So if anybody asks you what are avoidable contracts within the context of capacity to contract, these are contracts in which a minor acquires an interest in some matter of a permanent nature, which gives rise to continuous or recurrent obligations. These contracts, they are binding on the infant unless and until the infant repudiates these contracts within a reasonable time after attaining the age of majority. The authority for this principle is the case of Carter, C-A-R-T-E-R, versus Silber, S-I-L-B-E-R. What are some examples of contracts that you can describe as voidable contracts if you enter into such agreements with a minor? We have contracts for the purchase of shares in companies, marriage settlement, leases or purchases of land. Now again, about the leases, some of you will be using books where you'll be saying that we have made reference to Section 12 of the Conveyancing Act. Please, that Section 12 has been repealed. So the Conveyancing Act has been repealed. What we have now is the Land Act. And you will see a similar provision in Section 38, Subsection 2 of the Land Act. The next principle you have to note is that when an infant repudiates a voidable contract, he is liable for all the obligations that have been incurred by that particular infant prior to the repudiation, unless he can prove a failure of consideration. The principle is that when an infant repudiates a voidable contract, he is liable for all the obligations incurred prior to the repudiation, unless he can prove a failure of consideration. The authority is Steinberg. Steinberg is S-T-E-I-N-B-E-R-G. Steinberg, S-T-E-I-N-B-E-R-G versus Scala, S-C-A-L-A. What about loan contracts? If a person lends money to an infant and the infant refuses to pay, will the person be able to bring an action to recover the money from the infant? The common law is that a person who lends money to an infant cannot recover it at law. However, the person can recover it in equity, that part of the money that was actually used to purchase necessaries. So it means that if you're an adult and you give money to an infant and the infant defaults in paying, at common law, you can't bring an action against the infant to recover the money. But you will be able to bring an action to recover that portion of the money that the infant used to acquire necessaries. People have been wondering that since people enter the university and they are infants, 15, 16, 17, 18, since they are 21 years, when they acquire loans from the student loan scheme, can it be that then it means that the state cannot bring an action to recover those loans? Because we have learned that under common law, if you give a loan to an infant, you can't recover it. Bear in mind, because of this problem in the common law, we passed a law called the Student Loan Scheme of 1992, PNS Law 276. In this law, it has been mentioned that students who take loans under the student loan scheme, they are conclusively deemed to be treated as of full age at the time of entering into the contract. So if you are a person and then you are entering into a contract with and you are a minor and you are taking a loan under the student loan scheme, the law conclusively presumes you to be of full age at the time of entering into the contract. Therefore, for you, we'll be able to bring an action against you to recover the loan. What if the minor fraudulently misrepresents his age and then induces you, the adult party, to give the minor a loan or to enter into a contract? Now, the principle is that when the minor fraudulently misrepresents his age and thereby induces you, the adult party, to enter into a contract, that contract will still not be enforceable against the minor, despite his fraud. It means that if the minor shows you an ID card, making it look like he's 28 years, and thereby induces you to part with money and enter into a contract with the minor, the law is that the agreement will still be unenforceable against the minor. It means your loan, you will still not be able to recover it. So where a minor fraudulently misrepresents his age and thereby induces the adult party to enter into a contract, which is ordinarily unenforceable against the minor, that agreement will still remain unenforceable despite the fraud of the minor. If you want to now count your cause of action in the law of torts to bring an action against the minor or tort of deceit, that one too, the minor will also not be liable for the tort of deceit because the cause of action directly arises out of a contract which is not binding on the minor. The authority for this is Leslie Limited versus Shell. Leslie is L-E-S-L-I-E Limited versus Shell, S-H-E-I-L-L. But bear in mind, this is a common law, but in equity, the minor can be compelled to restore that property to the person deceived if the property is identifiable and it's still in the possession of the minor. It means that if the minor deceives you to part with a property or money to that particular minor, under the common law, you can't bring an action to enforce the contract. The money, you can't recover it. But under equity, you have been told that the minor can be compelled to restore the property if the property is identifiable and is still in the possession of the minor. And you know this particular rule, admittedly, it creates problems because it means that if the minor has deceived you to take some loan from you, it means you can only recover the money from the minor if you can identify the same notes and the same coins in the minor's possession. If the minor has changed the money, he has used the money and they've given him change, that money, you can't recover it because that is not the one that you gave to the minor. It has invested it and made profits. You can't go back and recover it because that's not the same money that you gave to the minor. So take note of the rules in Leslie Limited versus Shell. What about the right of a minor to enforce a contract against an adult party? Now, you remember I had mentioned from the beginning that generally under the common law, there are some agreements. The general position is that When a minor enters into an agreement with an adult, the minor can enforce against the adult, but then the adult cannot enforce against the minor. And then I have given you exceptions of contracts that the adults can enforce against the minor. I have given you contract for necessaries. I have given you beneficial contract of service, and you have discussed voidable contracts. Now, apart from these three, every other agreement that a minor enters into with an adult party, the adult party cannot enforce it against the minor. What about the minor? Can the minor bring an action for specific performance against the adult party? The principle is that the minor can only bring an action to obtain specific performance against an adult party if the minor has completely performed his side of the bargain in the contract and there's nothing more outstanding for the minor to do. That is when the minor can bring an action against the adult for specific performance, and the authority for that is Lartey versus Bannerman. This is what in some books you see it being referred to as mutuality of contract. That you, the minor, we can't bring an action against you for specific performance. So why would you want to bring it against the adult? The law is that only when you, the minor, you have completely performed your part of the contract, there's nothing outstanding for you to do, then you can bring an action against the adult for specific performance. The authority is Lartey versus Bannerman. When a minor is bringing an action in the court of law, can the minor bring the action by himself? The law is that no. If the minor is about to bring an action, the minor must sue through the minor's next friend, who must act through a lawyer. Or if the minor is being sued, he must sue the minor through the next friend or guardian ad litem. And over here, look at Order 5 of the CI 47. Is a minor liable for the torts? You know, you've learned law of torts. You know there's battery, assault, false imprisonment. Is a minor liable for their torts? The law is that generally minors are not liable. Generally, minors are liable for their torts. But where the cause of action is arising directly out of a contract, which is not binding on the infant, then the minor will not be liable for that particular tort. So take note, minors are generally liable for their torts. But where the cause of action in torts is arising directly out of a contract, and that contract is not binding on the infant, the minor will not be liable for the torts. What about the capacity of mentally incompetent persons? People we have described as people who are not compos mentis. Who are these people? A person of unsound mind, a person who we can describe as a mentally incompetent person, or an insane person, or a person who is not compos mentis. This is a person we can describe as a lunatic. Now, when these people enter into contracts, an insane person, a mentally incompetent person, they enter into an agreement with you. Must the agreement be binding on them? Remember, we mentioned there are times when it can be binding, there are times when it cannot be binding. Let's see, under what circumstance would the agreement entered into by a person who is insane? Under what circumstance would that agreement not be binding on that person? The case we'll use is imperial loan versus tone. Imperial loan versus tone. What does the court say? The court laid down two tests that you must meet before you can say that you are exonerated from liability under a contract because you are insane. First is that you must prove that at the time of contracting, you were of unsound mind. That is to say that you were incapable of understanding the nature of the contract due to the mental disability. That you were incapable of understanding the nature of the contract due to the mental disability, and this fact must be known to the other contracting party. The other party must be aware that at the time of entering into the contract, you were insane or you're mentally incompetent. So there are two things. One is that you were actually insane, and the fact of this insanity must be known to the other party. And the authority for this is imperial loan versus Stone. The burden of proving these two things lies on the person who claims to be mentally incapacitated. Now bear in mind, when a mentally incapacitated person enters into a contract, that contract is voidable at the instance of that particular person. If it's voidable, what does it mean? It means that it will continue to be valid unless the person takes steps to rescind the contract. But you are aware that there are some people who, even though they are insane, There are times when they are actually very sane. So you see them as insane, walking around as people who are mentally incompetent. But there are times when they are actually sane. We call it lucid intervals. There are times when they come back they are restored to normalcy and they appreciate whatever they are doing. The law is that we describe that period as a lucid interval or a lucid moment. Now, a mentally incompetent person is liable for contracts made during lucid moments, even when his disability is not known to the other party. And the authority is Selby, S-E-L-B-Y, versus Jackson. So a mentally incompetent person is liable for contracts made during the lucid moments, even when his disability is not known to the other party. And then there's this principle about mentally incompetent persons, about when a supplier has given a mentally incompetent person the necessaries, would an incompetent person be required to pay for them? Many people think that once you're a mentally incompetent person, regardless of the agreements we enter into with you, then it means it will not be enforceable against you. But if you read that case of Henry Rhodes, Rhodes is R-H-O-D-E-S, it states that a mentally incompetent person is liable to pay for necessaries supplied to him, where the supplier expected that the goods would be paid for, regardless of whether the supplier was aware of his disability. Again, a mentally incompetent person is liable to pay for necessaries supplied to him, where the supplier expected that the goods would be paid for, regardless of whether the supplier was aware of his disability. So people think that a mentally incompetent person, when you go and buy food, when you go and buy water, and there are necessaries, you cannot be sued for you to be compelled to pay. If you read the case of Henry Rhodes, R-H-O-D-E-S, it tells us that a mentally incompetent person is liable to pay for necessaries supplied to him, where the supplier expected that the goods would be paid for, regardless of whether the supplier was aware of his disability. Henry Rhodes. Then the final thing under capacity is capacity of intoxicated persons. What did we say about intoxicated persons? Remember that if it comes to the capacity of intoxicated persons, it's generally the same as that of mentally incompetent persons. Therefore, if at the time of the contract, a person was so drunk or intoxicated and he could not appreciate the nature and consequence of his act, and this fact is unknown to the other party at the time of contracting, that contract entered into will be voidable at the instance of the drunken or the intoxicated party. The drunken party has the option of ratifying the contract when he becomes sober. That is the case of Matthews versus Baxter. Again, a drunken person is under the same obligation as an insane person to pay a reasonable sum for goods that have been supplied. It means that if you're an intoxicated person and you're going to make an order for necessaries, just as you've seen for the insane persons, you too, you'll be required to pay if the supplier expected you to pay for the goods at that material time. Remember, these are the rules that relate to capacity to contract. You must go over them as many times as you can. If there's a principle that you know that I have mentioned that you're not aware of, quickly take the book, revise it, and take note of that one and move on. But if you can remember all of them, you are good to go. This is where we shall draw the curtains for our revision on capacity to contract. Now, next lecture, we shall deal with consideration. Thank you.